of newly empaneled arbitrators, I, on behalf of Delhi International Arbitration Centre, warmly welcome you all to this event. I take immense pride in welcoming Honorable Mr. Justice D.N. Patel, Chief Justice, High Court of Delhi, and Patron-in-Chief, Delhi International Arbitration Centre, along with the Honorable Companion Judges of the High Court of Delhi. I also extend a very warm welcome to Honorable Mr. Justice JR Midha, Chairperson Arbitration Committee. We welcome you, sir. For some reason, our Vice Chairperson, Honorable Mr. Justice Jayant Nath, is unable to join us today for this event, but I am certain that his good wishes are with us as always. I also take this opportunity to welcome the members of our Arbitration Committee, Honorable Mr. Justice V. Kameshwar Rao, Honorable Ms. Justice Rekha Palli, Honorable Mr. Justice Naveen Chawla, Mr. A.K. Ganguly, Senior Advocate, Mr. Nakul Devan, Senior Advocate. I also extend a very warm welcome to the members of the executive body of the Delhi High Court Bar Association, our esteemed arbitrators, learned members of the bar, distinguished guests, ladies and gentlemen. Today, while on the one hand, we feel euphoric on the inauguration of our new website, journal, audiovisual tour, and the list of newly empaneled arbitrators, at the same time, we feel a sense of void as our Honorable Chairperson, Justice Midha, demits office on the 7th of this month. I may be quick to add, however, that we are more than certain that Justice Midha would continue to enlighten us whenever we may require his support and guidance. With these words, I now request Honorable Mr. Justice JR Midha to kindly begin today's events. Sir.
Honorable the Chief Justice, Shri D.N. Patel, my brother and sister colleagues, all members of our arbitration committee, all the attendees to the function, I welcome you all to this function. You see, before we proceed further, I would like our Honorable Chief Justice to inaugurate the website, general, audio-video tour, as well as announce the list of the empaneled arbitrators. So, I will request our Honorable Chief Justice to first inaugurate the website by clicking on the website, and it will come on the screen.
I have already clicked.
Just 1 second. Ms. Bhuja, please see it not coming on the screen.
Yes, Manon.
All right, it has. I now request our Honorable the Chief Justice to please release the general. This is the first general of Delhi International Arbitration Center, and it has been very nicely done up. It has got very nice articles and very rich sharing of knowledge, and very renowned authors have given their contribution to this article. Honorable the Chief Justice, please release the general.
Okay.
We have lined up so many things to be released simultaneously today. So next we have the release of the list of the empaneled arbitrators which have been empaneled this year under the new amended rules which we introduced on 26th October 2020. We have selected 156 lawyers who have been empaneled as arbitrators. We have initially taken up the list of only the advocates. Other lists will take up at a later stage. So I will request our Honorable the Chief Justice to declare the list of the successful empaneled arbitrators. Now we come to the last release of today, which is the audio video tour of our arbitration center. We had been working on this for a very long time, but because of the COVID, the recording could not be done. There were COVID restrictions. Then some recording had to be done through the drone, but finally, with much difficulty, we were able to complete this assignment. And I will request the Honorable the Chief Justice to please release the audio video tour, which shall be displayed immediately upon being released.
Delhi International Arbitration Center. Your top destination for expeditious, cost-effective and credible resolution of disputes. Established on the 25th of November 2009 by the Delhi High Court, DIAC ensures effective settlement of disputes by arbitration. Surrounded by lush greenery, DIAC is located right in the heart of the city within the premises of the Delhi High Court. Spanning 2 floors, it offers 9 hearing rooms with varying seating capacities up to 20 persons. For smooth and seamless arbitral proceedings, all hearing rooms have dedicated secretarial services and support staff. Case management teams comprising trained counsels assist the arbitrators to administer the arbitration. DIAC ensures certainty of costs to the stakeholders through use of expedited timelines and transparent fee guidelines. With nominal administrative costs and no separate charges for hearing rooms and secretarial services, DIAC ensures cost-effective arbitration. DIAC offers real-time recording of evidence with live projection on large screens.
For a good institution, you need proper infrastructure, you need very good rules under which the arbitrations are to be conducted. You need a panel of good arbitrators who, with their impeccable integrity and proven merit, are able to do their duty well or discharge their function well. DIAC has all these attributes, and that is the reason that it has earned a lot of goodwill. I really commend Delhi Arbitration Center, which is doing so well, and I wish that it would keep on making further progress in this matter. Thank you.
In sync with today's requirements, video conferencing is also available to facilitate hybrid hearings. Arbitral orders and witnesses' depositions are provided to the parties instantaneously. Strict privacy and confidentiality norms are maintained at all times. There is an extensive panel of arbitrators comprising eminent legal luminaries and other professionals with varying specializations. For domain-specific disputes, professionals with area expertise are appointed as arbitrators. In addition to hearing rooms, consultation rooms for aggrieved parties and waiting rooms for arbitrators is available. Files are meticulously maintained in the record room. A fully functional pantry is in place to provide refreshments during the proceedings. The administration is run by a DHJS officer of the rank of district judge with the able assistance of DJS officers. The centre is headed by an arbitration committee which includes 5 High Court judges with the senior-most judge as its chairperson and also other members. For academic assistance, library and access to e-research platforms is provided.
There are many reasons why you should consider the DIAC as your choice for arbitrating contractual disputes. I would like to outline 3. The first is that the DIAC has world-class rules which bring about certainty and uniformity in procedure. The second is the schedule of fees prescribed in the rules, which enables a party to know the costs of arbitration at the time it is initiated. The third reason is DIAC's experienced case management team, the trained counsel who assist arbitrators in the administration of cases. All of these make the DIAC a great place to arbitrate.
Delhi International Arbitration Center, set up in the year 2009, has grown exponentially in the last 12 years. We are maintaining the highest professional standards in the center. We are expanding the center further by adding a new block in the High Court to meet the growing demands. Our vision is that this center continues to remain the most preferred arbitral institution in the country. The last 1 year had been a very hectic year. Despite COVID restrictions, we have taken various steps, including the 4 releases, which all of you have just seen. And we thought we will first release this, then we will, the success story, all the speakers are here. They will share the success story, how we have evolved and completed this work in a record time of 1 year. So I will request the center to please take up the matter and invite the speakers.
We extend our deepest gratitude to Honorable Mr. Justice D.N. Patel, Chief Justice, Delhi High Court. It is my absolute pleasure and honor to now invite Mr. Nakul Diwan, Senior Advocate and Member Arbitration Committee, High Court of Delhi, to address the gathering.
The Honorable Chief Justice of the Delhi High Court, Honorable Chairperson of the DIAC, respected judges of the Delhi High Court, and all my learned friends at the bar, warm welcome to all the new members of the arbitration panel. I have the privilege of addressing you on this momentous occasion as a member of the DIAC's committee. I've had the privilege of being closely associated with the DIAC since 2017-2018, when the then acting Chief Justice of the Delhi High Court, Honorable Justice Geeta Mittal, had asked me to become a part of the committee. In the pre-pandemic days, we would hold meetings in the DIAC's exemplary facilities. And I, having just returned from Singapore, had come up with a lot of ideas about my experiences, not just in Singapore and London, but also with the MCIA. What was most fascinating part of the entire committee of the DIAC and all the judges who form part of that committee was their ability of taking these ideas and contextualizing it in the reality with which the DIAC operates. And there is one very important aspect which I wanted to highlight during this talk. During our committee meetings, there would be a lot of discussions amongst the members of the committee when the DIAC was faced with cases where somewhere midway through the case, the parties would not have enough money to pay the arbitrator's fees. Now, this is not an issue which arises in normal, in other arbitration centers, because they simply follow the traditional model where if parties don't pay the fees and the claimant cannot pay it, the arbitration gets suspended. But members of the DIAC and its committees and the arbitrators who were part of that committee never took that approach. The approach they took was that if a litigant had come to the DIAC, then everything should be done in order to ensure that the dispute gets resolved. There were instances where arbitrators were willing to forego their fee in order to ensure that the dispute reached its finality. That was very unique to the DIAC. That is still very unique to the DIAC. And that is why, despite all the internationalization which the DIAC has done over the last 5 or 6 years, in my view, it stands out as an arbitration center because what I would call it is that it is a people's arbitration center. That distinction, my lords, members of the committee, and the new arbitrators who have come on board, is what will always differentiate the DIAC from every other arbitration center. And that is an ethos which I hope never changes. And just to give you an idea of how well recognized the DIAC is, I was in Hong Kong in 2019, and there was a discussion on arbitration centers. And a question came up about which center was the only center in the world that had amended its rules in 2018. And in an arbitration committee of international arbitrators, it was pointed out that the DIAC was the only center. And let me tell you, I was not the person who brought that up. It was brought up by an arbitrator who had come from the United States of America. Over the last 1 year, we have faced a number of issues which have related to the cancellation of a number of physical hearings. And one of the USPs of the DIAC is the fact that it affords and gives people a hearing room. I must only say that Justice Midha, as the chair of the DIAC, has come out as a true captain during this pandemic days. He has taken steps to ensure that we move from physical hearings to virtual hearings as far as the DIAC is concerned. Very early on in the pandemic, he called for a committee meeting where he gave us his suggestions on how it should go forward as far as virtual hearings are concerned. Sir, we're very grateful to you as members of the committee for the steps that you have taken as far as the DIAC is concerned during this pandemic days. Like I've said, you have acted as a true captain. This is not the only sphere, sir, that you have acted as a true captain. Sometimes we crib about some of the judgments which come across from judges. But let me give you an example of a judgment which I think has been a truly remarkable judgment in the arbitration field. It's the judgment, sir, in Bhandari Engineering. Sometimes we appear on one side, sometimes we appear on the other side. But let me tell you that from the perspective of enforcing arbitral awards, it is a truly remarkable judgment which takes in the best practices from international judgments and is a great step for arbitration lawyers, as well as arbitration practitioners, as well as the field of arbitration. As a member of the committee, we will find it very hard to replace some of the things that you have done. But we look forward to now welcoming you to the other side, and hopefully you will take on more arbitrations and continue guiding us in this sphere. Thank you very much.
Thank you.
Thank you, sir, for your compliments, and we wish to live up to your expectations. Now I humbly request Mr. A.K. Ganguly, Senior Advocate and Member Arbitration Committee, Delhi High Court, to say a few words.
Honorable Chief Justice of the Delhi High Court, Justice Midha, other honorable judges, and my dear colleagues of the Arbitration Committee, and the new members who have joined the DISC. I feel a bit nostalgic when I have to speak on DISC because it was for the first time in 2009 I was requested by the then Chief Justice of the Delhi High Court in some other forum that I've heard you speaking on many issues concerning arbitration. We are very critical about our system and we only point out all the deficiencies. But you seem to have some positive approach to it. Can we do something? That was the question he asked me. So I needed clarification from him to define what is we. Is that you and me? Or who else you imply? No, he said immediately, no, I really mean, can the High Court do something? So my spontaneous reaction was, I haven't thought about it, but give me a little time, I'll come out if I have an idea to present it for you. Within the next 1 or 2 days, I get a call from the Chief Justice. Enough of thought, he should immediately meet. Of course, I was thinking on this subject. So I explained to him, yes, there is a possibility. High Court is a constitutional body, authority. So whatever the High Court does, it is subject to public scrutiny of all. Now, in order to promote a center for adjudication, maybe informal adjudication like arbitration, there are no guidelines either in the Constitution or in the High Court of Delhi Act where you can take inspiration from. But I told him that data they got from going ahead with setting up of an institution, because you are now mandated under the Civil Procedure Code that every single case which is being tried in a civil court, the judge must in first instance try and resort to the possibility of a settlement either by mutual discussion or through any other area, including the arbitration center. So if that is the mandate of the CPC at that time, after the amendment was introduced, said what is the machinery you have or any high court has to suggest an arbitration, except leaving the parties to fend for themselves, go on an ad hoc basis, whosoever you want as an arbitrator, and then as and when the arbitration award comes, we will then be able to look into it. So it was possible, I suggested, and therefore I suggested that the High Court passes a charter, because the charter should explain the conditions that had inspired the High Court to create this body. And I wish all of you should have a look at that charter. In fact, it used to be printed as a part of the rules of DISC. The first set of rules which were published, the charter was on the very first page of the set of rules. But I don't find it there anywhere. But I would surely request all the members of this committee to please run through that so that you get to know the spirit in which the High Court came to set up this solution. Then the question was about what kind of institution we should have. We had to frame the rules. I was again interested with that responsibility. With the help of some of the honorable judges, then who were also interested in the field of arbitration, we were able to frame the rules, which I would tell you may have some resemblance with other international arbitration centers. But these set of rules that we have in the DISC are typical Indianized. There are many features in these rules which you do not find anywhere in any other institution in the world. You can, when you read them, you will be able to realize all those provisions. There were two motto behind this institution and the two rules. The object was, as Justice Midha said, and that's what the object in your demonstration you gave just now, in your audio-visual demonstration. The two are twin objectives. One is cost effective, and second was time effective. They both are very important criteria. So the cost effectiveness, as you know, litigants must know in advance what are the financial stakes for them in order to get the final result till the stage of an award. So the cost is a most important factor that should inspire the litigant. In order to inbuild that confidence in them, we'll set up this set of rules which gives a list of all costs which the parties would be expected to incur under various heads. Then the question was of time effectiveness. How do you control the time? Because in each arbitration, you may appoint an arbitrator in the center. The tribunal will go on the way it wants and the way the parties want him to do so. Now, in order to cut short the time, which are mostly consumed at the initial phases of arbitration, we decided, and that is part of our rules, that no sooner the pleadings are filed, that is, along with the statement of claim, the party claiming must file all his documents so that his filing is complete. Within a time frame, the other party will file their response with all their documents. And on the first day of sitting, the arbitrator must draw up what are the points for determination, which is the areas on which the parties are at loggerhead, and then also determine all the subsequent stages. That is, whether there will be a trial on oral evidence or not, whether arbitration will proceed only on documentary evidence. If it is going to be tried, then how many witnesses on each side? You fix the dates. On day one, the entire schedule could be fixed, including the dates for final hearing. We can push back. All that was provided part of the rule. So practically on day one, and this is being followed by many international arbitrations. I'm part of many of such organizations, including SEA and ICC. Many arbitrators at the international level, which are, where the arbitrators are very keen to maintain the time factor. This is being done. Our rules provide for it. That was something very unique. Elsewhere, they do it because of their own option. It depends on the arbitrator themselves. But here we have institutionalized the time management by framing our kind of rules. And I'm very happy that we have been quite successful. Justice Midha, apart from being a very, very, fine human being, a brilliant lawyer in his time, equally a judge with a lot of compassion and a progressive thinking, has contributed immensely to the development of law, not only by rendering judgments, authoritative pronouncements, but thinking, in its innovative thinking. For example, the process of execution is well known in our country. There's a saying that the litigation begins only after you file an execution petition, not for getting a decree. The entire actual litigation begins with an execution because the execution never ends. So it is Justice Midha's innovative ideas. He invoked all possible powers that the law confers on the court, including Article 227, all the powers in the Civil Procedure Code, and he devised a method amazing that on day one, the judgment data must produce in an affidavit entire detail of assets, so that your execution cannot be delayed unreasonably. Remarkable, and we thank Justice Midha for that. And he is, Nakul also mentioned about his contribution in the field of arbitration. Sir, your judgment in Bhandari engineering is a path-making judgment, I would say, and it will be very much appreciated not only in the country, but this would be a landmark judgment to be followed elsewhere in other parts of the world, because wherever we have the question of enforcement of an award and under the New York Convention, these issues will come up. And your approach that the implied consent of a foreign agency who is, by giving consent to arbitrate itself, is the end of the matter, and therefore the so-called protection under the Civil Procedure Code, etc., would not apply. Remarkable, sir. These are all path-making judgments, and we would remember these and forever. You had been a good teacher always. I remember that you had been teaching in the Delhi Law School. All your students admire you as a good teacher. I've heard about your ability for teaching. You are a great academic, no doubt. You have shown your academic excellence in so many of your writings, apart from the judgments. In DISC, I must say, as was mentioned, you had a lot of innovative ideas. Even in this difficult time of pandemic, although apart from legalizing or rather initiating virtual proceedings of arbitrations, I remember you introduced one rule. We did it by a kind of a executive order, not a formal rule. Said that parties can supplement their arguments if they can't present themselves before the arbitrator online. They can do a video, graphing of their contentions, and then send the contents of it in any form. Remarkable, and we adopted that. I don't think any other arbitration center has ever, any other institutions ever had been so much imaginative. But we did provide for that. So I have to thank you, Justice Midha, for those great innovative ideas. This institution has been lucky to have all of you, Justice Midha, Justice Navin Chawla, and other honorable judges, Justice Rao, Justice Palli. All of you put together would enrich this institution further. I have absolutely no doubt about it. I definitely feel extremely privileged and honored that you gave me the opportunity to come and speak to you. Thank you so much, sir.
Thank you.
Thank you, sir. It has been extremely enriching for us to hear your discourse about DIAC rules. We have amongst us Honorable Mr. Justice Navin Chawla, Judge, Delhi High Court, and Member Arbitration Committee, High Court of Delhi. Sir, could you please address the gathering?
Justice D.N. Honorable Justice JR Midha, my companion judges in the High Court, judges and officers of the District Court, as also of the DIC, learned arbitrators, the newly impaneled one, the old ones, lawyers, ladies and gentlemen.
Well, today we've met on this virtual program for two agenda items. One I'll call an official agenda item, which was the inauguration or the release of the DIAC website, its journal, audiovisual tour, as also the list of impaneled arbitrators. And the second is a personal agenda item, which is to bid farewell to Justice JR Midha. Well, I will be concentrating only on the second one because Mr. Ganguly, Mr. Diwan have already spoken about the DIAC. We've also seen the achievements of DIAC in that virtual tour and the website. As far as Justice Midha is concerned, well, he, as a judge, has been a true pioneer. He has crafted a path and has removed hurdles wherever he found one, in the statute or the rules. Wherever he was faced with a situation where he found that the rules of the act itself is found wanting in a particular manner, he would not hesitate by an administrative order in a way, though of course it was a judicial order, to bridge that gap, to actually carve out that path for what he in fact is, I think, is in his own words, discovering the truth. So as a judge, he has been a fearless judge. He has also been a pioneer, a path-breaking judge. As a chairperson of this committee, he was appointed on 11th March 2020. So his entire tenure has really been in this pandemic. But then this did not deter him from working as a chairperson of this committee or to in fact give his inputs and his, I will say, his guidance towards a betterment of this institution itself. During this pandemic itself, he would ensure that we would regularly meet, bring about amendment in the rules which were very much required. There were some complaints from the arbitrators about the other things. We wanted to, address that quickly. Also, this empanelment of arbitrators, I must say, he's the one who really pushed hard on this. Yeah, in fact, forced us to, in fact, do the interaction in the vacations because he wanted that this should not now get delayed any further. So as a chairperson, there are things which are for all to see as to how he's really improved this institution itself. But I think most important about him is his personal outlook towards life. He's a God-fearing, kind, humble man. His kindness and humbleness we have experienced firsthand, being his junior when we joined the bench. He would never ever express his seniority to us. He would in fact be most willing, most accommodating, most forthcoming in his suggestions. In fact, we take lunch together. So after having lunch, we'll all hover around him because he'll definitely have one joke for all of us on a day. Enlighten us to just give us a little more thing to sit after lunch and have our day pass. He also is my badminton buddy. Now, for a senior, you never say buddy. But he's the one who I have no doubt, treated me like a buddy. His enthusiasm for that game, I am sure it cannot be matched even with a 21-year-old. You have to see him play that game. How competitively he plays that. So as a human being, I must say that he has been par excellence. I'm sure Justice Midha does not treat his retirement as an end of road, but a beginning of a highway, where now he will roar and he will just pass, brazen manner. He has his passion in teaching. I'm sure he is going to continue that. In fact, teaching and guiding us also on various ways. Arbitration is certainly, sir, one of the things which I'm sure lawyers attending this seminar are just waiting for 8 July to pass, and then they are going to flood you with that. So I don't think that you are going to have any free time thereafter. I wish you all the very best, and it's really been a pleasure and an honor to be part of a committee with you, to be part of the bench with you, to know you in personal capacity like this. Thank you, Rick.
Thank you, Numin.
Thank you, Lordship, for the kind words and the words coming straight from your heart. I would now invite Honorable Ms. Justice Rekha Palli, Judge, High Court of Delhi, and member, Arbitration Committee, to say a few words.
Honorable the Chief Justice, Justice Patel, Justice Midha, all my brother and sister judges, members of the High Court Bar Association, ladies and gentlemen, a very good evening to you, especially to the newly impaneled arbitrators. A big congratulations to you. As we all know, Justice Midha is going to be with us for a few more days, discharging his duties as effortlessly as he does. I mean, you go to his court and you won't feel that he's passing any order. You will have that humane angle there. But we thought we must take this opportunity of thanking Justice Midha today for the contributions he has done as a chairperson to this arbitration center. This Justice Midha is, though a lot has been said about him, I would say describe Justice Midha that he is three qualities. I don't know whether he's aware. He's a person with passion, vision, and compassion. All the three things, and I think that was one of the most important things which a judge, I mean, that's in my little experience, I would say, a lot of people would have vision or passion, but they don't have that, they may not have that compassion. So Justice Midha was actually an amalgamation of all the three things, which is reflected not only from his judgments, where he has laid down so many guiding principles for times to come. I mean, for the next so many years, all the judges will have to follow most of the guiding principles which he's laid down in so many of his decisions. But today, I don't think there'll be enough opportunities when people will talk about his judgments. Today, I think I must only say that Justice Midha, in the arbitration center, he has been not only a leader and a mentor to us, but he has earned so much respect. He did not actually ever exercise his authority. He would only, when you were in the room with Justice Midha, the atmosphere was so jovial. Everybody was put at ease. As even as the junior members of the committee, we were allowed, and in fact we were encouraged to share our opinion. And even if we differed with Justice Midha, he was more than happy to accept it. That is the quality he has, the quality of a great leader. So I would say, Justice Midha, this quality is something very few leaders will have. And this is what will make it impossible for us. I don't know how we are going to forget you or once we have a new leader here, it will be very difficult for us to work. We will keep comparing the manner in which you led the team. And Justice Midha, as Justice Chawla also said and Mr. Diwan also said, in the lockdown when everything was coming to a standstill, the judicial system, obviously under the leadership of our Honorable the Chief Justice, kept moving. The wheels kept moving. Similarly, the arbitration system under the leadership of Justice Midha kept moving from March 2020 when the country was under lockdown. We moved the system. We encouraged the arbitrators to continue to work because Ms. Justice Midha was very conscious of the fact that people are waiting for justice. So we, as has been already highlighted, not only was the list of advocates who were to be impaneled finalized, the rules were finalized, so many other things. The website which I'm sure will bring laurels to this center, was inaugurated under great restraints. But it has now been achieved, and when that clip was being played, I could see the smile on Justice Midha's face that yes, this is what I sat on with and I have done it. So I would just say, Justice Midha, I don't want to take further time. We'd like to hear the other speakers also, but all the best to you, and I'm sure you will be happy in whatever you do in life always. Whatever, you are such a spiritual person that you will be happy always. All the best to you, sir, and thank you.
Thank you, Rekha. Thank you very much.
Our Lordship, Chairman Sir has been very aptly described by my Ladyship in these three golden words: passion, vision, and compassion. Because if we start discussing His Lordship's success stories, time would always fall short. Thank you, Ladyship, for sharing your thoughts. I would now invite Honorable Mr. Justice V. Kameshwar Rao, Judge, High Court of Delhi and member, Arbitration Committee, to share his thoughts.
Justice D.N. Patel, Honorable the Chief Justice, Justice JR Midha, the Chairman of the Arbitration Committee, my colleagues on the bench, Mr. A.K. Ganguly, Mr. Nakul Diwan, the senior advocates who are members of the Arbitration Committee, the other members of the Arbitration Committee, Mr. Mohit Mathur, the President of the Delhi High Court Bar Association, all the dignitaries who are present, all the newly empaneled arbitrators, all the officers of this court, ladies and gentlemen, a very good evening to all. We have assembled today on the occasion of virtual inauguration of DIAC Journal, DIAC website, and audio-visual tour brought out by the DIAC. This function coincides with Justice Midha demitting the office as a judge of this court on 7th of July 2021, and as such, as a chairman of the Arbitration Committee. Justice Midha started practicing as an advocate in the year 1982. While practicing as an advocate, Justice Midha joined Campus Law Center, Delhi University, as a part-time lecturer. This was immediately after my senior, my Guru Justice Sikri, had completed his term. He taught various subjects like CPC, Indian Evidence Act, Motor Vehicles Act, to name a few. I think there is hardly any lawyer or a judicial officer in Delhi who has studied in the Campus Law Center between 1989 and 1992 has not been taught by Justice Midha. I think one of his students is a judge of this. Justice Midha was given the mantle of the Arbitration Committee, which looks after the working of the DIAC by the Honorable the Chief Justice in the month of March 2020, when we were in the midst of COVID-19 pandemic. Despite the pandemic, the committee under the guidance of Justice Midha held meetings through video conferencing to work out the modalities to ensure the arbitration proceedings are conducted by the center through the learned arbitrators are not stalled, and important decisions with regard to the working of the DIAC are taken. During the last 1 year, the committee, in order to keep up the consistent growth, had updated the DIAC rules framed earlier to bring out uniformity, certainty, and more stability in the arbitration process. DIAC, which maintains a panel of experienced arbitrators comprising of legal luminaries, including the former Chief Justices of India, former Supreme Court judges, former High Court Chief Justices, retired district and session judges, senior advocates, have been recasted by preparing a panel consisting of 454 arbitrators. The committee has prepared a roadmap for encouraging institutional arbitration under the aegis of the DIAC. The Journal of Arbitration released today, which incorporates the history and origin of the institutional arbitration under DIAC and the articles written by the sitting and retired judges of the Supreme Court and this court, the other high courts and senior councils, shall go away in that respect. That apart, the committee has also initiated a process to fill up the vacancies of deputy counsels who shall be assisting the learned arbitrators. Justice Midha, as a judge of this court, has made immense contribution in the development of law. A reference of the judgments rendered by Justice Midha has already been incorporated in the journal. I shall refer to two judgments which are, I think, path-breaking. The one is Rajesh Tyagi versus Jaivir Singh, where Justice Midha has formulated special scheme for time-bound settlement of motor accidents claims within 90 to 120 days, which was implemented with effect from 2nd April 2010. This court has gradually improved the said scheme by various orders to ensure that the procedure for settling the claims of victims of road accidents is hassle-free, just and expeditious. As has been pointed out by the earlier speakers, in a recent judgment in Bandari Engineering, Justice Midha had formulated 3 affidavits to be filed by the judgment debtor at the very threshold of the execution proceedings. The affidavits are very comprehensive and are useful to determine whether the judgment debtor has the means to satisfy the decree and award. In fact, in a recent order of mine, in an execution proceedings, I had referred to the judgment authored by Justice Midha and directed the judgment debtor to file an affidavit in terms thereof. Justice Midha's judgments, if I can put it, are a learning experience which deals with every argument addressed before him. The same reflect the brevity, the clarity, and focus approach in a true sense. My interaction with him since my elevation has revealed that he also practices meditation. His knowledge of religious scriptures and places is immense. On a lighter note, as pointed out by Justice Chawla, his sense of humor is unparalleled. He has a knack of narrating jokes, which he has in abundance, generally taken out during the lunch break. Surely, on Justice Midha's demitting office, I and most of the members of this committee shall be missing his company on the badminton court. It's just a coincidence. I and Justice Chawla are one side. In general, it happens. And Justice Nath and Justice Midha are on the other side. He is a formidable opponent whose skills to pick up every shot of the opponent at the nets are unmatched. And Justice Chawla will agree with me there. I hope and desire that Justice Midha shall continue his pursuits on the badminton courts in future as well, and shall be coming to the High Court. I take this opportunity to wish Justice Midha a long, healthy, happy and fulfilling life ahead. And best of luck, sir, in all your future endeavors. Thank you very much.
Thank you, Brother Rao. Thank you very much.
Who doesn't misses the college days? A smile on your face was clearly seen, my lords. Thank you, Lordship, for those kind words and also highlighting the attributes of our chairperson. Thank you. I have now the honor to invite Honorable Mr. Justice D.N. Patel, Chief Justice, High Court of Delhi, and Patron-in-Chief, DIAC, to address this august gathering.
Good evening to everybody. Justice JR Midha, Chairman, Delhi International Arbitration Center, my sisters and brother judges of Delhi High Court, Justice V. Kameshwar Rao, the member of the Arbitration Committee, Justice Rekha Palli, the member of the Arbitration Committee, Justice Naveen Chawla, the member of the Arbitration Committee, Mr. Mohit Mathur, Senior Advocate President, Delhi High Court Bar Association, and who is also the member of the Arbitration Committee, Mr. A.K. Ganguly, Senior Advocate and a member, Mr. Nakul Diwan, Senior Advocate and a member, newly empaneled arbitrators, judicial officers, ladies and gentlemen. I'm very much delighted to be a part and parcel of today's function and release of the journal, audiovisual tour. The empaneled advocates list has been released and a website has been launched. Since last 2 days, I am hearing about Justice Midha's qualities, the judgment, path-breaking decisions, the nice nature of Justice Midha, badminton player, and whatnot. I have seen his game, excellent player he is. You see, one must know at least a few games, and they will be very useful at an advanced age. Even if you can't play, you can look at TV and can appreciate the players and their games. In the recent years, the arbitration has emerged as a robust mechanism for disputes resolution. With its already well-known advantages, the arbitration process can further be bolstered by the way of institutionalized arbitrations. Established on 25th of November 2009 as a first ever High Court annexed institutional arbitration center, Delhi International Arbitration Center was conceived to be an independent and autonomous institution that encourages and supports the growing demand of the institutional arbitration in India. The DIAC Charter, which determines its core value, sets twofold objectives. That is, the arbitration proceedings at DIAC are inexpensive and are concluded within a reasonable time frame. DIAC has made a significant contribution to the growth of arbitration as an effective catalyst to the dispute resolution mechanism by providing state-of-the-art infrastructure with 9 fully equipped hearing rooms, pre-established rules and procedures, equitable fee structure, and outstanding administrative and secretarial support for the conduct of the arbitration proceedings. Located in Delhi High Court premises itself, DIAC offers a centrally located and convenient venue. The proceedings and the fees under the aegis of DIAC are governed by its own set of rules. To keep up with the consistent growth of DIAC rules are updated from time to time. DIAC is soon going to be shifted its operations to a more sizable premises. The upcoming arbitration center is proposed to be located in a new block of Delhi High Court campus. The functioning of the center is looked after by a distinguished arbitration committee of the Delhi High Court, which comprises of the judges of the Delhi High Court, ASG attached to the Delhi High Court, President of the Delhi High Court Bar Association, senior advocates, and the advocates. The committee looks after all policy matters, including the rules and the procedures followed by the center. Day-to-day functioning and the general administration of the center is managed by the coordinator and additional coordinators assisted by deputy counsel. During the course of the journey of 11 years, DIAC has witnessed an exponential growth across all parameters. DIAC has a humble beginning with only 3 matters referred to it in the year 2009, which has now been scaled up to 3,022, and so far 1,713 matters have been disposed of under the aegis of DIAC. These encourages the members and reflects the faith reposed by the disputants in the DIAC. With its docket of international arbitrations referred by the Honorable the Supreme Court of India and domestic arbitrations referred by various other high courts, including the high courts of Karnataka, Punjab and Haryana, and the dais has shown its strong presence on the map of arbitration and the arbitration map of India. The center also maintains an extensive panel of 630 experienced arbitrators comprising of eminent legal luminaries, including international arbitrators. This panel is reviewed from time to time, and today we are also declaring a new list of arbitrators to be empaneled with DIAS. The list is now already available. I congratulate each of them and welcome them to the DIAC. During this time of pandemic, the DIAC became a leading institution to bring the international best practices in need of this emergency situation. After resumption of its partial functioning from 8th June 2020, the DIAC started holding the hearing through video conferencing, which is provided by DIAS without any additional charges. In order to facilitate these hearings seamlessly, a detailed guidance note is notified, which takes into account all the possible difficulties that could have been faced by the parties, the counsels, and the arbitrators while conducting the hearing through video conferencing. The The detailed guidance note covers all the aspects of the arbitral proceedings right from the stage of the filing of the reference till the pronouncement of the award. Each hearing conducted through VC is facilitated by the deputy counsels appointed by the dais who ensure the seamless conduct of the hearing through VC. For simultaneous recording of the hearing, the DIAC has also provided the facility of trained stenographers in the VC hearings. Today, we all have gathered here to witness the new website of the DIAC and the Journal of Arbitration of the DIAC, and the new modern interface of the website, especially designed keeping in mind the requirement of the convenience of the disputants, the lawyers, and the arbitrators. Some of the significant features of the website include online fee calculation, access to DIAC, panel of arbitrators, real-time availability of hearing rooms, cause lists, and the DIAC publications. Justice Midha was appointed as the chairman of the DIAC in March 2020. Under his leadership, DIAC has introduced stage-wise dispersal of fees, wherein arbitrators are paid fees for every stage of arbitration, which has been concluded by the panel by the arbitral tribunal. Justice Midha has also revised the administrative charges of the DIAC, which is commensurate to the services provided by DIAC, while ensuring that the charges are competitive. Justice Midha has also contributed significantly in launching and in drafting of the website of the DIAC. The online case management system is still underway and is likely to further expedite administrative proceedings of the arbitral matters. Under Justice Midha's leadership, DIAC has published its journal and revamped its empaneled rules. I also congratulate the arbitration committee for coming up with an idea of publishing a journal. The publication of the first issue of DIAC journal is an endeavor of the DIAC to provide its readers with a well-researched articles authored by prominent personalities in the realm of arbitration. With its periodic newsletters and journal, DIAC ensures that the readers are kept well aware with the latest developments. DIAC has also an internship program with the aim of providing practice exposure to the law students in the field of arbitration. Despite time-space constraints, the DIAC has successfully maximized its operations and pioneered as arbitral institution of repute. However, in the coming times, it has a capacity to unleash a higher potential. As a patron-in-chief of this prestigious institution, I take pride of its achievements and extend my full support to its aims and objectives. Once again, I congratulate Justice Midha for the achievement of the DIAC. Sir, you are retiring, but you are retiring only from services and not from our hearts. Thank you.
Thank you, Lordship, for your ever kind words of wisdom and encouragement. We are indeed blessed by your Lordship's gracious presence. I have now the pleasure to invite Honorable Mr. Justice JR Midha, Judge, High Court of Delhi and Chairperson, Arbitration Committee, to address this august gathering.
Honorable the Chief Justice, Shri D.N. Patel ji, my brother and sister colleagues, all the members of the Arbitration Committee, Mr. Mohit Mathur, President of High Court Bar Association, all the officers of Delhi International Arbitration Center, all the attendees of the function here, very good evening to all of you. I'm very grateful to the Honorable the Chief Justice and all the speakers who have showered so much good wishes and said good things about me. I have known more things about me by hearing all of you. About First, I'll take about DAC working. The Honorable the Chief Justice reposed confidence in me, and I was appointed as chairperson on 11th March 2020. So, after I took over, the first thing which I noticed was that very few cases were being referred to the arbitration center directly. Rather, it is only MSME Act. They have incorporated a clause, and the cases of MSME Act were only majorly being referred here, and which are very small matters. So, I discussed with the Honorable the Chief Justice that we can expand the DIAC by approaching the government and PSUs. There's so many bodies, and the Honorable the Chief Justice, with his blessing, then I took up the matter with the learned ASG, with also the Standing Council of Delhi government, that they can incorporate a clause in their agreements. For example, Delhi government has PWD, Delhi Jal Board, DSIDC, central government, so many PSUs are there, and they will have a wonderful benefit of the working of the DIAC. So we had prepared that list of all the PSUs and all the heads and their contact numbers also. But because of the pandemic, this thing could not take off. But in the meantime, in order to make that effort, we had made all arrangements. We requested the Honorable the Chief Justice to give us some additional administrative persons from the High Court on deputation, which the Honorable the Chief Justice immediately allowed it. And we had a joint registrar, and we had a deputy registrar, assistant registrar, accounts people, and we are totally geared up to start with that. And in that line only, we also prepared this. We looked at the all the websites of all international arbitration centers all over the world, and then we thought that everybody has got their own website and audio visual tool. So then we engaged the agency with the approval and guidance of the Honorable the Chief Justice, and we told those people that we want an audio video tool which is better than all the international standards. So, and we called them, we examined all the agencies, we looked their past work, then we showed them all these audio visual tours of all the international centers, and then the audio visual tool which all of you have seen. To my mind, it is one of the finest which we have been able to achieve. Then, when I took over, there was a lot of grievance by the arbitrators that the fees is not being released in a phased manner. Fees is being released at the end. And we immediately convened a meeting. We deliberated upon. We also took the guidance of the Honorable the Chief Justice, and then we immediately amended our rules. And now the fees is being released in a phased manner. Then also the arbitrator's grievance was that at times there is a delay. So we have taken the accounts people from the High Court on deputation, and now the fees is being released even within 2-3 days, at maximum within 1 week of the fees being due, the fees is being released. The next thing we noticed was that for a large number of many years, we had not enrolled the arbitrators. So the bar had a grievance that why it is getting delayed. So then we found that our rules were little more complicated, which would have taken a long time. So we had a lot of deliberations and we modified our rules. And this modification we had done on rules we modified in just 1 second. October 2020. Immediately after modifying the rules, we invited the applications from 1st December to 31st December. Then because of the COVID, Mr. Mohit Mathur, the president, requested that we should extend by 15 days. We extended that. And then after examining all the applications, we prepared a list of eligible and not eligible. Then we thought that maybe because of the COVID, some lawyers may not have been able to furnish the documents. So in order to avoid any inconvenience, we in the committee decided that we will again give an opportunity. So on the website, we published the list of all eligible and those found not eligible. And we said, if you still have some document to furnish, we extended that time, and then in a very short time, then we had a subcommittee here, and we requested that even during COVID, please take up the matter expeditiously. And I'm very grateful, Justice Naveen Chawla, Justice Rekha Palli, and Mr. Nakul Dewan were the members. They interacted with the candidates, and we came out with a list in a very, very short time. But we are very grateful to the Honorable Chief Justice for guiding us through all this process to make all these things happen in a very short time of 1 year. We also wanted to within 1 year to also invite all the PSUs and government bodies, but because of the COVID situation, that was not possible. But I am very sure that the arbitration committee will continue on these deliberations, and this arbitration center will be the best arbitration center in the country. So this was our 1 year, which we have been able to perform in 1 year. Now, the one more thing which I think I would like to share. After my elevation in 2008, in June 2008, there was a conference in Singapore in which I, Justice Sikri, Justice Paul, and Justice R.C. Lahoti, we all visited there. When we visited there, we visited the Supreme Court of Singapore, and there we were told that the Supreme Court of Singapore, a new building has been constructed, and the old building has been converted into an arbitration center, which is a court-managed arbitration center. So we were taken on a visit to the arbitration center. We saw the rules also. Then we brought back all those rules, and we briefed Chief Justice A.P. Shah, who then constituted a committee in which Justice R.C. Lahoti was the former CJI, was the chairman, and there were 23 members, and finally all these rules came out, and we were able to bring out a center which has got very fine rules. We have, as Mr. Nakul Dewan has said, these are very fine rules as compared to even international standard. So that is one thing which we have done. I'm very, very thankful for the very statements made by the speakers about Bhandari judgment, and which also I've written an article in the General, and I'm quite sure this Bhandari judgment will bring a respite to all the degree holders or award holders. One more area which I would like to share, in which I have tried to develop the law, but I think furthermore will be developed. You see, the Arbitration Act section 34 contains a clause, section 34, subsection 2. Explanation 2 says that an award can be set aside if it is against the most basic notions of morality or justice. Now, most basic notions of morality and justice has not been interpreted. It was rather for the first time it came in Justice Nariman's judgment in Associate Builders, where he has explained the meaning of morality and justice. This judgment came in 2015. But prior to that, in 2014, a case came before me in which I invoked this doctrine. And it was a very interesting case. I'll share very brief facts with you. You see, a bank had taken a property on rent from the landlord in Noida for around, I think, 10 lakh rupees. After 2 years, it was a long lease. After 2 years, the rent dropped. So the tenant approached the landlord that either you reduce the rent or I will vacate the property and take the adjoining one, which is available for half of the price, or 5 lakh rupees. So the landlord examined, rates had actually fallen. So landlord agreed to reduce the rent from 10 lakh to 5.5 lakhs or so. And a supplementary lease deed was executed, but it was not registered. Tenant started paying the rent on reduced rent for 3 years. After 3 years, the landlord one day said that you please give me according to the original 10 lakh rupees. And he raised a dispute which was referred to a retired judge of Allahabad High Court. The landlord took the plea that supplementary lease deed is not registered, therefore it cannot be looked into, and the award was passed in favor of the landlord, giving the rent at the rate of 10 lakh rupees. The challenge to that award came before me. I took a view that although the supplementary lease deed cannot be looked into, the award is legal, but the award is against the most basic notions of morality and justice. You have agreed to reduce the rent. That document is not disputed, and you have raised a false claim by denying a statement. So in that, I issued a notice under section 209 of IPC, and also said that this is against the most basic notions of morality and justice. And also took a view that Arbitration Act goes further. A civil court, section 9, the CPC appeal doesn't permit the civil court to go into morality. The lawyer can there say that please look into legality alone. But Arbitration Act goes a step further. It says that if the award is legal, 100% legal, completely law has been complied with. But if it is against morality and justice, so in one of my judgments which I have announced on 21st January 21, I have interpreted the terms morality and justice, and also given reference to that 2014 matter. But I am sure this point will ultimately be interpreted, and the interpretation will be set at rest. But there is not much law on this. It is a very interesting point, I think, which needs to be developed. And there were few other areas on which arbitration I wanted to develop the law. I had heard those matters at quite length, but the time was short. I could not pronounce. On some other platform, I'll share my views on that. But here, I am today very, very thankful for all of you having showered so much good wishes and blessings on me. And I'm sure I would have a good life after uh, demitting office from here. Rather, yesterday one of my colleagues commented. He said normally people get sad when they're getting retired, but you feel very happy and excited. I said yes, I am very, very happy and excited, and I'm waiting for that freedom because I've worked here with full passion. In fact, I must concede I didn't lead a balanced life in my passion to do to work here. I ignored. So today I have not ignored all my areas of my life just to complete my passion of doing work here. I wish I'll be able to live a balanced life now after retirement. Rather, today morning during my meditation, I was thinking that as if if a person builds that Empire State Building, then after that he would like to sleep for some time and have a long rest after that. So I am having like that feeling. I'm very excited and happy that I have played the innings well, and all of you have showered so many blessings. I'm thankful to all of you, and I will never forget the words which you have today said in my favor. Thank you very much.
Thank you, Lordship, for sharing your heart with us, your thoughts. They are so enriching. The aspects of referral of cases to DIAC, visualizing the audio-visual tour, addressing the grievance of the arbitrators relating to fee, the empanelment rules modification, inviting fresh applications for empanelment, and lastly, giving us some vision on the concepts of morality. All these are really, really very enlightening for us. I now extend our heartfelt gratitude to Honorable the Chief Justice and companion judges of the High Court of Delhi for their kind presence. I remember the Honorable Chief Justice's visit to our center at DIAC way back. I'm really thankful, my lords. I extend our sincere thanks to the Arbitration Committee of the Delhi High Court and its esteemed members for their presence and participation. I now extend our wholehearted thanks to Honorable Mr. Justice JR Midha, Judge High Court of Delhi and Chairperson Arbitration Committee. Lordship, we have really been fortunate to see the developments that have taken place in DIAC during your Lordship's tenure and also be a part of it. Here I wish to recite a Sanskrit quote, Nabha Sparsham Deeptam, the tagline of Indian Air Force, which means reaching the skies with glory. With this quote, Lordship, we heartily extend our best wishes for your Lordship's good health and future endeavors. I also thank other respected dignitaries who have participated today. I'm grateful to Mr. Manoj Jain, worthy Registrar General of this Honorable Court, and pay our thanks to him. I now extend a vote of thanks to the entire dedicated team of DIAC, led by Ms. Kaveri Baweja, Coordinator, and my esteemed colleagues, Ms. T. Priyadarshini and Mr. Nishant Garg, Additional Coordinators. I also thank the officials of the IT branch for their technical support. I thank the participants for making this event successful. Good evening. Namaskar.